Right now, as you're watching this, the Supreme Court of the United States is being asked to decide who gets to be an American, not in theory, not as a thought experiment, in an actual courtroom with actual lawyers, arguing about actual children born on American soil. The case is called Trump versus Barbara, and the decision could strip citizenship from millions of people who have spent their entire lives believing they were Americans. But here's what nobody is telling you. This isn't a new argument. This isn't something invented in 2025. This is the final chapter of a story that started 158 years ago with an amendment written to protect the most excluded people in American history. And every step along the way, the law got stretched a little further. Each decision used the last one as its foundation. Each reinterpretation opened a door that the next one walked through. By the time we're done, you'll understand exactly how we got here, and you'll understand why the next chapter involves artificial intelligence. Let's start at the beginning. Dred Scott was an enslaved man. He had lived in free territories. He argued that made him free. The court said no. Chief Justice Roger Taney went further than just denying his freedom. He ruled that Black Americans, enslaved or free, were not citizens, were not persons under the Constitution, had, in his exact words, no rights which the white man was bound to respect. That ruling stood for 11 years. It took a civil war, 620,000 dead, and a constitutional amendment to reverse it. In 1868, Congress ratified the 14th Amendment. Listen to the Citizenship Clause. Really listen to it.
All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens. 39 words, written to do one thing: make sure no court could ever again say that an American-born person was not a citizen. Senator Jacob Howard, the amendment's author, explained exactly what it meant on the Senate floor. Subject to the jurisdiction thereof meant anyone present in the United States and subject to its laws. No exceptions for race, no exceptions for political allegiance, no asterisks. The amendment was airtight, unambiguous. The most expansive citizenship guarantee ever written into American law.
It lasted 18 years before someone found a way in. His name was Roscoe Conkling, senator from New York, one of the most powerful politicians of the Gilded Age. He helped draft the 14th Amendment. He knew exactly what it said and what it didn't. He left the Senate and became a corporate lawyer. In 1882, he stood before the Supreme Court representing the Southern Pacific Railroad, and he made an argument so audacious it's almost hard to believe it worked. He told the court the men who wrote the 14th Amendment specifically chose the word person, not citizen, because they intended it to cover corporations too. He produced what appeared to be a journal from the drafting committee, showing the framers deliberately debating citizen versus person, and landing on person on purpose. Historian Howard J. Graham later concluded that this part of Conkling's argument was, and I'm quoting directly, a deliberate, brazen forgery. The court didn't know that. The court listened. 4 years later, the railroad case that actually came before the Supreme Court was Santa Clara County Vars. Southern Pacific Railroad, 1886. California had taxed the railroad's fences differently than it taxed individual property owners. The railroad said that violated the 14th Amendment's Equal Protection Clause because corporations were persons and deserved the same treatment as individual citizens. The Supreme Court ruled in the railroad's favor, but on a tax technicality. They never actually ruled on whether corporations were persons under the 14th Amendment. But before arguments even began, Chief Justice Morrison Waite said something from the bench. He said the court didn't need to hear argument on the personhood question because, in his view, the amendment already covered corporations. He just said it before arguments, not in the opinion, not voted on, never debated. The court reporter, a man named Bancroft Davis, who had previously worked as a railroad executive, wrote that statement into the headnote, the summary at the top of the published case. And there it sat, in the official record, looking like law, cited as law, treated as law, a clerk's note, never decided, never voted on. For the next 124 years, it was the foundation of corporate constitutional rights in America. Here's how legal precedent works. Once something is in the record, the next court cites it. The court after that cites both. Each citation adds weight. Each decade, the foundation gets harder to question. By the early 1900s, corporations had 14th Amendment due process rights. By mid-century, they had Fourth Amendment protections against unreasonable government searches. By the 1970s, they had First Amendment protections for commercial speech. No single court ever stopped to ask, wait, Was that head note actually a ruling? Because each court was citing the court before it. The chain was self-reinforcing. The error had become the law, each link built on the last. Each decade, the amendment drifted further from the freed slaves it was written to protect, and further into the world of corporate boardrooms. And then came 2010, when the chain reached its logical endpoint. The case was Citizens United versus Federal Election Commission. Citizens United was a nonprofit. It wanted to air a film attacking Hillary Clinton during the 2008 primary season. Federal law said that counted as an illegal campaign expenditure. Citizens United said the law violated their free speech rights. The Supreme Court agreed, 5-4. But follow the chain of reasoning, because this is where 1886 finally pays its dividend.
In 1886, corporations became persons under the 14th Amendment, and as a person, corporations are entitled to have First Amendment free speech rights. Then, in 1976, Buckley versus Valeo established political spending is a form of speech. Therefore, corporations have a constitutional right to spend unlimited money on elections. Right?
That's the entire argument. 4 steps, each one built on the last. The whole chain leads back to a summary written by a former railroad executive before a case was even argued. Justice John Paul Stevens, 89 years old when he wrote the dissent, said this:
"Corporations have no consciences, no beliefs, no feelings, no thoughts, no desires."
Then he retired and spent the rest of his life calling for the decision to be overturned. President Obama said it out loud at the State of the Union, with the justices sitting right in front of him.
"I don't think American elections should be bankrolled by America's most powerful interests, or worse, by foreign entities."
Justice Alito, who wrote the Citizens United majority, silently mouthed the words, "Not true." Senator John McCain, who spent years building the McCain-Feingold campaign finance law called Citizens United.
The worst decision in the history of the Supreme Court.
Elizabeth Warren put it the plainest of all.
Corporations are not people. People have hearts. They have kids. They get jobs. They get sick. They cry. They dance. They live. They love. And they die.
She said that in 2011. The law didn't change. Now I need you to hold 2 things in your head at the same time. For 140 years, the legal system used the 14th Amendment to expand who counts as a person with constitutional rights. It started with freed slaves. Then it stretched to corporations. Then to corporate free speech. Then to unlimited political spending in elections. Every expansion used the amendment's flexibility as a feature. Courts kept finding new meanings in old words. Now, the same argument, the same words, the same 5-word phrase, but pointed in the opposite direction. In January 2025, President Trump signed an executive order ending birthright citizenship for children born to undocumented parents on U.S. soil. His administration's legal argument, subject to the jurisdiction thereof. The position, undocumented immigrants entered the country illegally. They owe political allegiance to another country. Therefore, they are not truly subject to U.S. jurisdiction. Therefore, their U.S.-born children inherit that incomplete allegiance. Therefore, the 14th Amendment citizenship guarantee doesn't apply to those children. Every single federal court that heard this argument blocked it immediately. But the administration didn't fight those rulings on the merits. They went to the Supreme Court and argued that lower courts didn't have the power to issue nationwide blocks in the first place. The Supreme Court agreed, 6-3. The nationwide injunctions were struck down, which meant the constitutional question, does Trump's order actually violate the 14th Amendment, was never fully resolved, which is why on April 1st, 2026, the Supreme Court hears oral arguments in Trump v. Barbara. Trump v. Barbara is a class action suit. The families challenging the order argue the administration is asking for, and I'm quoting their brief directly, nothing less than a remaking of our nation's constitutional foundations. The administration's counter-argument, the courts have been wrong for 128 years. That United States v. Wong Kim Ark, the 1898 case that gave birthright citizenship to the U.S.-born child of Chinese immigrants who were legally barred from ever becoming citizens, was incorrectly decided. That the original meaning of subject to the jurisdiction thereof was always narrower than any court has acknowledged. And here's the detail that will make a constitutional law professor drop their coffee. One of the key precedents being argued in Trump versus Barbara is an 1844 New York inheritance case called Lynch v. Clark, a dispute over a dead man's estate. It hinged on whether his U.S.-born daughter was an American citizen. The New York court ruled, yes, born here, citizen here, no conditions, no asterisks, an 1844 inheritance case, is now a pivotal precedent in the most consequential citizenship ruling in modern American history. The same Supreme Court that gave corporations constitutional personhood, using a headnote that was never voted on, authored by a former railroad executive, is now being asked to decide whether human beings born on American soil are Americans. The amendment hasn't changed. The words haven't changed. Who gets to be a person under them? That question has never stopped moving. Let me show you the whole chain one last time, because once you see it, you can't unsee it. 1857. The Supreme Court rules that Black Americans are not persons under the Constitution. 1868. Congress writes the 14th Amendment to make that impossible. All persons, born here, subject to our laws, citizens. 1882. A corporate lawyer who helped write the amendment argues it was meant to cover corporations too. He may have forged the evidence. 1886. A former railroad executive, now the court reporter, writes that argument into a summary before a case is even argued. It's never voted on. It enters the official record. 1900s, 1970s. Courts cite it, then cite those citations. Corporate rights expand with each decade, each link pointing back to a clerk's note. 2010. That headnote's great-grandchild, Citizens United, gives corporations a constitutional right to spend unlimited money on elections. The chain is complete. 2025. The same amendment, the same 5 words. Now used to argue that human beings born on American soil don't qualify as citizens because their parents' allegiance was incomplete. 2026. The Supreme Court decides. And somewhere in a law firm right now, the briefs have already been filed. There are lawyers arguing that artificial intelligence systems deserve legal personhood under this same amendment, because if a corporation with no heartbeat, no conscience, and no body can be a constitutional person, why not a machine? That's the next video, and I promise you, it goes somewhere you won't expect. If this connected some dots, that's what this channel is for. Subscribe, because we're just getting started. And if you're watching this on April 1st, 2026, go look up what the Supreme Court decided today. Then come back and tell me I was wrong.